do exactly that. And it's a normal process that happens. The PS help me do this better. I'm delegating you to take us with the background on this, and then the legal, the lawyers.
Proceeding.
Let's cover ground by starting. Yes.
Thank you, Chair. Seek for your guidance. My colleague raised
Suppose they know they are supposed to present that. They are supposed to present the bill. They are supposed to present the certificate of financial implication. He knows. One of the boss is he knows what to do. So let them start.
So
you cannot present the certificate of financial implication before you introduce the bill.
I have to introduce
He has to introduce the bill.
The
He has to introduce the bill. After the bill, the certificate will come. Even your ruling will definitely be explained.
procedure. The bill was introduced in the House, was
Yes,
tabled, and then forwarded. So that is an allegation the colleague is making, which would be clear.
Actually, it is alleged.
Certificate also will come, and then you can proceed.
They want to get the thing before the head. What are we getting by the head or the seat?
No, Minister, proceed.
Thank you very much.
Thank you very much, Chair. Prime Minister. We've got the background to the amendment of the Uganda People's Defense Forces Act, CAP 330, to structure the legal defense, to suit emerging threats, challenges, and circumstances. Cabinet under Bill 266, Chair of CT 2016, directed the Minister of Defense and Veteran Affairs, Minister of Defense then, one, to amend the Uganda People's Defense Forces Act, CAP 330, and accordingly repeal the Uganda Veterans Assistance Board Act, CAP 221. The principles of the bill were cleared by Cabinet on the 21st of November 2022, and Minute 408C.
Aggravated robbery, kidnap with intent to murder, cattle rustling, treason, and misprision of treason. Section 117A to F on page 46. Schedules 7A and 7B specifying arms, ammunition, or equipments ordinarily the monopoly of the defense forces and classified stores. And for ease of reference, 7A is at page 73 of the B, and then 7B is at page 76. Clause 35 on page 49 introduces section 192 to establish the unit of marshal and in each unit of the defense forces, its compositions, qualifications of chairperson, who should be a holder of a bachelor's degree in law and a diploma in legal practice. It also provides for the jurisdiction of the court to try offences whose sentence do not exceed 5 years. It also provides for an appeal from the unit court martial right to the general court martial. And the composition is the chairperson and 2 other members. And when there is a matter of law, the decision of the chairperson is final. Clause 36 on page 52-53 introduces section 196, which establishes a division court martial, and in each division or equivalent formation chaired by an advocate of the High Court, who will be appointed in consultation with the Judicial Service Commission. It provides for the composition and qualification and
would please you to supply the honorable members with a copy of that law made reference to, right from Parliament to the Ministry of Defense, across that there is a cross reference.
You want a copy of this?
I have it. To the benefit of these other members, may not share my program.
Appointment of in the composition of members of the court martial. So that has never happened. That brings the civility in the process of administering justice in the military court martial. To us, based with the advice of the Attorney General, who did a lot of research, we compromised on that. That now, in the appointment, we shall do it in consultation with the Judicial Service Commission. If I was saying this somewhere else, I would have asked for the applause. But now, since I'm in the Committee of Parliament, everyone is looking at me as if I have not said anything sensible. I want to thank you, and that marks the end of the presentation of the bill, and I want to play the copy of certificate of financial implication, which I know that you already have. But since it was demanded
of that fact, and I'm not introducing anything new to warranty exceptional circumstances. But Honorable Chair, the lawyer in you, the advocate in you knows so well that murder, rustling, and all these cases can be ably tried in the High Court and the entire appearance system of the courts of record. So where is this coming from? Isn't the minister trying to impute ill motive on the part of the Supreme Court in using their ruling to say they were given room to override the Constitution in bringing these amendments? Because I have been carefully trying to see where is the gap, where is that lacuna they're trying to cure. I cannot trace it. So, Honorable Chair, for me, I am not sentimental, I'm not emotional. I am tracing for what the Constitution says, and where the Constitution commands, I am obliged to obey. I am failing, and I'm failing to say a single clause that makes the court martial a court throughout these proposals. Not improving the personnel to say, as long as the personnel is, the chairperson is an advocate of the High Court, that cannot turn it into a court. Otherwise, I'll sit here and turn you into a court because you're an advocate, so am I, so several others. With Mr. Chwaka, yourself, senior Cartoon, and we say, as long as Cartoon to herself for 25 years, yours is now a gesture of the Court of Appeal. We become part of, so it's not a question of qualification, it's not a question of service, it's a question of the Constitution, Honorable Chair. I am waiting that single statement here that confirms that these amendments have changed the command of the Constitution in what is a court. Thank you.
Thank you. Let's have
Honorable Minister, of course, when the Honorable colleague asked almost at the tail end, as it comes out, true, it's going to be staggered, but there is a requirement of 143.7 billion shillings starting 2025-2026 financial year, this sector. Now, for us as a sector, I don't know whether this is